You want the best possible example of weaponizing the prosecutorial process? Look no further than Mark and Patricia McCloskey. Viva Frei, Montreal litigator turned YouTuber, and I have a feeling the Mark and Patricia McCloskey case is going to be the next judicial saga that will carry us for another year. For those of you who may be living under a judicial rock and don't know who Mark and Patricia McCloskey are, they are the Missouri couple who brandished firearms at a group of BLM protesters over the summer. It led to mass media coverage. It actually led to them being indicted on charges of brandishing firearms and tampering with evidence, but we're getting ahead of ourselves. Mark and Patricia McCloskey are a very wealthy white couple, and I ordinarily never pay attention to these types of identity politics type issues, but it's relevant for the context of this story, so I need to point it out. I should also point out that they are both attorneys with something of a reputation, so if you are going to weaponize the prosecutorial process, maybe
don't pick two highly litigious attorneys to do it to.
During the summer, over the course of BLM protests across America, apparently a group of protesters made their way into the McCloskey's private community. Some say they just made their way onto the streets peacefully. Others say that they broke down a metal gate to enter. I don't know exactly what happened. I only see pictures on the internet and read media coverage, but those are the two diverging stories of how a group of protesters came to be outside the McCloskey residence. The McCloskeys, fearing for their safety, brandished firearms at the group of protesters, told them to move on while the protesters chanted. That was the end of the story until they were indicted on charges of brandishing a firearm. The image of the couple brandishing their firearms also made for one of the best memes of all time, but I am getting distracted. Let's get back to the story. So the McCloskeys were indicted on charges of brandishing a firearm, which already had a lot of people outraged. People saw it as a violation of Second Amendment rights. People saw it as a violation of the fundamental right to self-defense. But it gets even worse. It turns out that in the context of the investigation, after the firearms were seized, the pistol itself was not operable because Ms. McCloskey had made it inoperable to use it as a prop during a trial. It seems that in the context of the investigation, Ms. McCloskey's pistol was in fact disassembled by the investigators and reassembled in order to be operational so that Ms. McCloskey could be charged with the crime. Indeed, under the law, the charge itself required the pistol to be readily capable of lethal use, so if the pistol had been rendered inoperable, Ms. McCloskey could not be charged with the crime, so the investigators apparently disassembled the weapon, put it back together to make it readily capable of lethal use in order to charge Ms. McCloskey. What? What the fuck? Now, if the indictment itself was not shocking enough and this act was not shocking enough, what happened next is going to absolutely blow your mind, because it turns out that the McCloskeys themselves were then indicted on charges of tampering with evidence. Now, I have been vlogging this each step of the way, so if you want to go back and watch some of my older videos, which will give a more detailed breakdown of each step I just described, go ahead. It'll keep you busy for about an hour, but what happens in this story now is
absolutely amazing.
The McCloskeys filed a motion to disqualify the circuit attorney and the circuit attorney's office from the file given some of their conduct. The motion was granted, and the conduct is absolutely shocking. St. Louis prosecutor taken off case of couple who brandished guns at BLM protesters. Vanessa Romo. The St. Louis prosecutor spearheading the case against Mark McCloskey, one half of the husband and wife team accused of menacing Black Lives Matter protesters with weapons, has been removed from the case. Circuit Judge Thomas Clark II on Thursday dismissed Circuit Attorney Kim Gardner and her entire staff, saying campaign fundraising emails Gardner sent to constituents that alluded to Mark and Patricia McCloskey's case, quote, raise the appearance of impropriety and jeopardize the defendant's right to a fair trial, end quote, the Associated Press reported. The ruling means Gardner can no longer oversee McCloskey's prosecution. Instead, a special prosecutor will have to be selected to take over. The decision does not apply to McCloskey's wife, Patricia, who is scheduled to appear before a different judge on January 15. That is the 30,000-foot overview according to the mainstream media, but I actually got my hands on the judgment itself, and what the judgment says is absolutely going to blow your mind as to how Kim Gardner weaponized and politicized this entire prosecution. Weaponized, politicized, and exploited for the purposes of fundraising for her election campaign. Missouri Circuit Court, 22nd Judicial District, City of St. Louis. State of Missouri, plaintiff versus Mark McCloskey, defendant. Order. Before the court is, quote, defendant's motion to disqualify the circuit attorney and the circuit attorney's office, which was called, heard, argued, and taken under submission by the court on October 28. On that date, defendant appeared in person with his attorney Joel Schwartz. State of Missouri appeared by and through Assistant Circuit Attorney Christopher Hinckley and Rob Hook. The case history is as follows. On July 20, 2020, a circuit attorney charged defendant by complaint with 1 count of unlawful use of a weapon, subsection 4, exhibiting Class E felony. On July 29, defendant filed his motion to, quote, disqualify the circuit attorney and the circuit attorney's office, end quote, with attachments including Exhibit A, July 17 email sent from votekimgardner.com, 2 pages, and Exhibit B, July 22 email sent from votekimgardner.com. Some procedural stuff we can skip over. I just want to get to one particular line and one particular footnote because it gives an indication as to what the judge thinks of Kim Gardner. The court takes judicial notice of the court file, including the various motions, pleadings, and attachments filed in this matter. Footnote 1. On November 17, Ms. Gardner filed, quote, state's response to defendant's supplemental motion to disqualify the circuit attorney and the circuit attorney's office, end quote, without receiving leave of court to do so. Her supplemental response, coupled with the motion requesting leave to do so, was filed 68 days after defendant submitted his supplemental motion and 20 days after the hearing when the court took this matter under submission. Despite this, the court considered this pleading. Just so the non-lawyers can really appreciate what is going on here, this is saying that Kim Gardner, through counsel, filed a supplemental response to the defendant's supplemental motion 68 days after it was originally filed and 20 days after the judge took the matter under deliberation. That is to say that after all the procedure had been filed, after the parties had argued before the court, after the court took it under deliberation, 20 days later, Kim Gardner, through counsel, filed their response to defendant's supplemental motion to disqualify, and the judge did not take kindly to this. He said as much in his footnote, and he says, notwithstanding all of this, I still considered it, and I'm still disqualifying you. Now, what was the basis for Mark McCloskey to ask that Kim Gardner and her entire office be disqualified from the file? Well, it turns out they were exploiting of this prosecution in order to raise funds for her re-election campaign. More specifically, defendant asserts that Ms. Gardner generated and distributed 2 different email solicitations requesting money for her re-election campaign by linking the external criticism to defendant and the incident resulting in criminal prosecution. Defendant contends that not only was this improper under the relevant legal standard, she was aiming to energize her supporters and elevate contribution amounts by referencing the defendant and his alleged criminal conduct in campaign solicitations. In sum, Ms. Gardner's solicitations were made at the expense of defendant, compromised her professional judgment, and warrants removal from the case. Conversely, Ms. Gardner requests that the court deny the motion, citing case law, advisory material, and even a most recent Missouri Supreme Court decision that strongly cautions the trial court against replacing the voter's choice to represent the interests of the people. The judgment then goes over the facts, which we don't need to do because we've already done it, just to pay attention to a couple of specific dates, the date of the indictment and the date of the email soliciting money. On July 20, Ms. Gardner charged the defendant by complaint with 1 count of unlawful use of a weapon exhibiting a Class E felony following an incident occurring at defendant's residence on June 28. Shortly after the June 28 incident, but prior to charging defendant, Ms. Gardner issued a public statement expressing her concern about the incident, claiming, quote, peaceful protesters were met by guns, end quote. Likewise, various media outlets also interviewed defendant, and the incident received widespread media attention. Following the criticism, but before charging defendant, the Gardner campaign distributed the following email to supporters on July 17. Dear blank, because you are a supporter of Kim, I want to make you aware of a few late-breaking developments that are making national headlines right now. You might be familiar with the story of the couple who brandished guns during a peaceful protest outside their mansion. Well, today the governor of Missouri weighed in, telling the press, quote, President Trump understands the situation in Missouri, he understands the situation in St. Louis, and how out of control it is for a prosecutor to let violent criminals off and try to attack law-abiding citizens. Instead of fighting for the millions of Americans affected by the pandemic, including 31,000 Missourians, President Trump and the governor are fighting for the 2 who pointed guns at peaceful citizens during the Black Lives Matter protests. Both President Trump and Governor Parsons, sick, are playing politics at a time when they should be doing their elected jobs. Hashtag confession through projection. Kim Gardner is accusing Trump and the governor of Missouri of playing politics at a time when they should be doing their elected jobs? This coming from someone who is using the incident to raise money for her re-election campaign. Accuse your enemies of doing what you are doing so as to create confusion.
Moving on.
Kim needs your help to fight back. Her election is only a few weeks away, and right now she is under national scrutiny from our divisive president, the Republican establishment of Missouri, and the right-wing media, including Fox News. Will you show Kim you stand with her and rush a donation today? St. Louis will have an opportunity to re-elect progressive circuit attorney Kim Gardner, who time and time again has shown us she isn't afraid to stand up and hold those accountable who are perpetuating a system of systemic racism and police brutality. Kim needs your help. Please make a donation of $5, $10, or $25 right now. Thank you. Hashtag Team Kim. VoteKimGardner.com, July 17 email, Exhibit A. And what does Kim Gardner do 3 days after sending out this email exploiting of the situation to solicit donations for her re-election campaign? She charges the defendant Mark McCloskey. Then what does Kim Gardner do? 2 days after charging defendant Mark McCloskey, she sends out another email again requesting money. I'm not even going to read this one. I'm just going to put it up on the screen so you can read it at your leisure with some nice relaxing music in the background. The judge then gets into the discussion of the conclusions at law, which I'm only going to skip over summarily because it's not going to really interest anybody all that much, and we already know how this ends, but just to read a couple of key paragraphs. Conclusions of law. Defendant refers the court to the revised statutes of Missouri as authorizing prosecutorial removal when warranted. More specifically, Section 56.110 of the Revised Statutes of Missouri reads, if the prosecuting attorney and assistant prosecuting attorney be interested or shall have been employed as counsel in any case where such employment is inconsistent with the duties of his or her office,
duty.
The court having criminal jurisdiction may appoint some other attorney to prosecute or defend the cause. In applying Section 56.110, the courts have held that a prosecutor should be disqualified if the prosecutor has a personal interest in the outcome of the criminal prosecution, which might preclude affording defendant the fair treatment to which defendant is entitled. After considering the arguments of counsel, the pleadings coupled with the attachments, the applicable case law, and the relevant statute, the court finds the emails raise an appearance of impropriety and warrant disqualification. In short, the circuit attorney's conduct raises the appearance that she initiated a criminal prosecution for political purposes. But it seems that is exactly what she accused Donald Trump and the governor of Missouri of having done. Funny how projection works. Immediately before and after charging defendant, she solicited campaign donations to advance her personal interests. Apparently, Kim Gardner tried to argue that the defendant was making certain public statements and therefore that her statements were merely a rebuttal to his public statements. The circuit attorney reminds the court that defendant himself was making public statements surrounding the June 28 events. But defendant is not the elected prosecutor, Ms. Gardner is. Just because defendant is making public statements about the events surrounding June 28 doesn't authorize her to use the circumstances to her political advantage. Quote, the awesome power to prosecute ought never to be manipulated for personal or political profit, end quote. Instead, it is the solemn obligation to ensure, quote, that justice shall be done, end quote. State versus Holman. Gardner apparently then tried to argue that subsidiarily, even if she is disqualified from the file, that her office should not be disqualified. They can continue to work on it. She will just have nothing to do with it, to which the court said that is totally unrealistic. Everyone working in your office is effectively working under you, so if you're out of the file, so is your entire office. And then just to hammer the point home, in the conclusion, the judge reiterates the following. The statute is explicitly clear and without any ambiguity, allowing the court to remove the prosecutor if the prosecutor has a personal interest in a particular case. The campaign emails demonstrate the circuit attorney's personal interest in this case, raise the appearance of impropriety, and jeopardize the defendant's right to a fair trial. Among other previously described concerns, these email solicitations aim to raise money using the defendant and the circumstances surrounding the case to rally Ms. Gardner's political base and fuel contributions. And just to allow Kim Gardner to save a little bit of face, the judge offers her the following grace. While the collateral consequence of the emails may have been inadvertent or unintentional, quote, intention is not a factor under the legal standard. The legal standard only requires that the court conclude that the conduct appears inappropriate. Applying the case law, the court finds this legal standard is satisfied. State versus LeMasters. The judge is sort of saying, maybe you didn't mean to do it, Miss Gardner, although we all know you darn well meant to do it, but maybe you didn't mean to do it. But even if you didn't mean to do it, too bad, you did it, and now you gave the appearance of impropriety, you are disqualified. But at least now you can hang your hat on that second to last paragraph and say, but I didn't mean to do it, I just didn't know. Oh well, lessons learned. Now, apparently this judgment only applies to Mark McCloskey and not Patricia McCloskey. Apparently she's in front of another judge on January 15, 2021. So we'll see what happens there, but this is a good indication of where this file is going. To be continued, because I have a feeling this is going to be another legal and political saga, and I will be there all along the way. And if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm.
Feed me all night long.
If you want to support the channel, all of the support links are in the pinned comment. We've got PayPal, Patreon, Subscribestar, YouTube membership. Robert Barnes and I have a page on Locals. It is called vivabarneslaw.locals.com, where you can support us there. But more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out.